Hello, my name is Thomasina Thornton, and I am a licensed New York and New Jersey trust and estates attorney. Welcome to this segment of Estate Planning Essentials. This is part 3 of the segment on power of attorney documents. Now, if you missed parts 1 and 2, then I would invite you to check out my Facebook page, the Law Offices of Thomasina Thornton, or my personal page, as well as joining my Estate Planning Essentials group. Or you can catch all of my videos on YouTube. Now, with that said, let me give my disclaimer. By no means am I trying to give you specific legal advice, and you can understand why. Every person's situation is going to be different. People may live in different states, and each state will have their own statutory provisions. Now, if you live in the states of New York and New Jersey, and you have questions, by all means, give me a call. I would love to talk to you. But if you live outside of those states, then I would suggest that you seek counsel in the state in which you reside. Now, with that said, let's get started. Now, allow me, if you will, just to give a very brief recap of parts 1 and 2. In part 1, I discussed what is a power of attorney. A power of attorney is a legal written document that gives another person the authority to make legal and financial decisions on your behalf. Part 2 discussed who needs a power of attorney document. What I'd like to talk about in this video is how do you go about choosing the person who is going to make those decisions on your behalf? How do you choose your fiduciary? Or the term that we use in the power of attorney is your agent or your attorney in fact. Just to give you some things to consider in making those decisions. Choose someone that you trust implicitly. Someone that you are willing to disclose information about yourself, your financials, what your objectives are, who the key people in your life would be. Again, someone that you believe is going to be honorable and who will ultimately abide by your wishes. So after you've found that person who is trustworthy and who has integrity, then you want to ask yourself the next question: is this person able to make tough decisions in tough times? And here's what I mean by that. Sometimes an agent may be in a position where he or she may have to make a decision that other people in your family or friends may be opposed to. So will that person be able to stand strong in their conviction that they're making a decision that is in your best interest, either from a legal or a financial position, regardless of who may have contention with that decision? The next consideration that you want to think about when you're looking for a good agent is making sure that that person is perhaps in close proximity. Sometimes it's difficult if you have an agent who lives across the country from you and you're having difficulty with communication, or that person has difficulty getting to your location. So you maybe want to consider, is that person in close proximity to me? Or will they also have the time? Meaning, if they've got busy lives and they're juggling a ton of things, will they have the time to be able to dedicate to helping you manage your own affairs? Another thing to think about when choosing an agent or an attorney, in fact, is that person's financial stability. You may want to ask yourself, has that person had financial issues of their own? Have they declared bankruptcy? Do they have foreclosures? Have they shared with you that they're going to other people to borrow money, or have they asked a loan from you? That may be something for you to think about, or at least give a second thought to when you consider having someone else manage your financial portfolio or your financial holdings. Now, once you have decided on a candidate for your agent's position, then you want to really sit down and have a conversation with that person. I mean, I would suggest you look them in the eye and tell them the things that you would expect of them. And then let them tell you that, yes, I do accept the position as your agent, and I do intend to honor your wishes. Now, once you have determined who is going to be your primary attorney-in-fact and agent, I also suggest you got to do this one more time and think about who would be the successor. Because again, life is funny. You never know. Something could happen to your primary attorney-in-fact, and then you're left in a lurch. So when considering who's going to be your primary, you also want to think about, if that person cannot serve in that position, then who would be the successor attorney-in-fact. Now, I know I have probably given you a lot to think about, but what I do not want is for you to get stuck. If you find someone, they may not meet every criteria, but maybe they meet most of them, then I would strongly suggest that you proceed with creating that power of attorney. And the good thing about a power of attorney is that if you want to make changes to it, you can revoke it at any time. Tear it up, contact the financial institutions and have a copy of it, and let them know that you have revoked it. But I would suggest that you try to make those decisions while you are healthy and you are mentally able to execute those types of documents, rather than when you are in poor health or you are under a stressful situation, and that makes it a lot more difficult to make a really good, proven decision. Well, this brings us to the end of part 3 of Power of Attorneys. Please join me for part 4, where I will be discussing things to consider before agreeing to serve as an attorney-in-fact or agent. I want to thank you for watching. I am Tommy Thornton. I'm a trust and estates attorney. If you have any questions, by all means, give me a call. I look forward to seeing you at the next video, and as always, I wish that you be well and live long. See you next time.